with association with MIT College of Railway Engineering and Research, Barshi. So, Saili ma'am, are you there?
Yes, yes, sir, I'm good.
Yeah. So we have the tradition before proceeding to any events, we will first play our the Vishwa Shanti prayer. So I request our technical team, please start the prayer.
आत्मरूपा देवा तूचि गणेशु सकलार्थमतिप्रकाशु म्हणे निवृत्तिदासु अवधारि गोजी गुरुर्ब्रह्मा गुरुर्विष्णु गुरुर्देवो महेश्वरः गुरुः साक्षात् परब्रह्मा तस्मै श्री गुरवे नमः। पूर्णमदः पूर्णमिदं पूर्णात् पूर्णमुदच्यते पूर्णस्य पूर्णमादाय पूर्णमेवावशिष्यते। ॐ शान्ति शान्ति शान्तिः।
Yeah, before proceeding to the session, so I request Professor Saili ma'am, please introduce our guest for the audience. So, Professor Roy, the theme is like this, that is, we have kept this webinar on two modes, that is, the audience will benefited it later on also, that is, we are recording the sessions and we are showing it on YouTube also.
Yes.
So don't bother about the audience. So we will start the session. So Saili ma'am, please proceed to the session.
Good afternoon, everyone. On behalf of MIT College of Railway Engineering and Research, I extend a heartfelt welcome to all of you gathered here today for this insightful webinar on intellectual property rights. Now, allow me to honor the introduction of our speaker for today's session. Mr. Roy holds a master's degree in pharmaceutical science and is a registered patent agent. He brings over 7 years of valuable experience in patent law, including prosecution, opposition, and litigation in the field of patent. Apart from his legal practice, he has also contributed to the academic field with 7 years of teaching experience delivering lectures at national and international forums on the patent regime. Throughout his career, he has been associated with prestigious organizations like Can and Cresswell, Mazumdar and Co., and the Intellectual Property Office at Kolkata. His areas of expertise span a wide range, including pharmaceutical, biotechnological, mechanical, and agricultural patents, along with handling IP/AB proceedings, patent licensing, and compliance with NBA and IDA protocols. We are truly privileged to have a professional with us today to enlighten us on the significance and implications of intellectual property rights. Without further ado, I now invite Mr. Roy to begin the session and share his valuable insights with us. Over to you, sir.
Thank you very much, ma'am. Thank you. Let me share my PPT first. Okay. You might see, I think, the PPT right now. Am I audible?
Yes, sir. You are
Yes,
audible.
yes, sir. We can see the PPT also.
Thank you very much. We can now start the session. Before going into the detail, I just would like to know the background of the audience. Basically, the faculties and students are belonging to which field? Engineering field, right? Maybe, right?
Yes, yes, sir. It is
Engineering in which branches?
So basically, we are running 5 branches, sir. That is computer engineering, mechanical, civil, electronics, such kind of branches.
In this audience, these peoples, this engineering, mechanical, civil, this kind of peoples are there, right?
Yes, yes.
Okay, fantastic. I have also prepared my presentation in that view. The second, before going into start into the sessions, I would like to know, and here, how many peoples are here right now? Around? Do you understand my question? How many? Is there anybody who filed a patent application or any other IP application in this right now in this forum? Is there any faculty from your college or any student from your college?
Right now, there are 2 patents are there, which is in the flow.
Okay, that is not granted, that is filed just, right?
Yeah, it is filed and
It is-
it is already published, sir, waiting for the examiners.
Waiting for the examinations report.
Yes.
First examinations report from the patent office. Is there any intellectual property file other than patent? Means, I mean to say, is there any copyright filing, design filing from your faculty or students? Other than patent, is there any intellectual property? Do you have any idea? No.
No, no, sir.
Okay, let me explain now. So, I think that basically in our society, in academic society of our country, the peoples are quite having such kind of fear, I think, right? Is it the fact the patent is difficult, it would not be obtained easily? Okay, this kind of mindset we have in our society, don't worry, eliminate such a mindset from your mind. Okay, patent has become easier now. No, obtaining the patent is quite easier in today's scenario. It is faster also as compared to the earlier. If we compare the durations of the processing and grant, it's quite faster. Patent could have been granted within 1 year also. I will show you such and that too from Solapur only. So fastest patent in our country belongs to Solapur. So I will show that thing. The patent is not difficult. Only need is we need to be little sincere. Here the picture is different. Here the first picture is different. In what sense? You know that it is different from your publications. The way you publish the paper, the writing part, the way of drafting the patent applications is different. Here, if you establish that 2 plus 2 is equal to 5, nobody is going to raise any questions. If you logically establish, scientifically establish that 2 plus 2 is equal to 5. Okay, but in your academics, if you are saying that 2 plus 2 is equal to 5, you need to have some valid reference, then only it will be considered. But in patent, suppose you do not have such kind of reference in your hand, but you are in a position in establishing such a scientific thought and scientific manner that 2 plus 2 is equal to 5. So patent office will consider it, will not raise any question. So assessment of patent application in a patent office is quite different from your PhD viva or any academic viva and that kind of and publications also. First thing which I've observed that the problem is you people are first published your patent invention, but disclose your invention anywhere in journal, in research journal, in review article, in any form, in YouTube, and then you come to us for filing a patent application. Do you know what happened? Each and everything is killed. Each and everything is killed. You cannot file your patent application because it's already disclosed. So, but same is allowable for the other thing. Don't confuse patent with other intellectual property. In copyright, it is allowable. You first publish but disclose your creation, article, literal copyright can be obtained for the, you need to know what subject matter is fitted in which act. If you write a book, that is subject matter, but if you write a lab manual, that is a subject matter of copyright. That is not patentable. Okay. But if you make a pen, if you make any device and that which you believe that it is nowhere. So for such subject matter, you could proceed for patent. But copyright, in assessment of copyright is there is no questions of newness. Means you first disclose your article, then you could file your copyright application, allow. But if you publish but disclose your invention and then you file the patent application, which is not allowed. So there is a different assessment. Now I'm coming one by one. Okay. Today we are going to deliver a talk regarding Indian patent practice and procedure. Indian patent practice and procedures, because first we need to understand our country, then other countries. This is a write-up. You could file your applications at your own. There is no problem. You need not to come to patent attorney. But problem is no. You do know what is the problem. You do not know the implications of the Patent Act, and which is not possible for you guys. Ultimately, you are a teacher. You are the objective of you is to teach the student. First thing, you are a researcher. Ultimate objective for you is to find out to do any research. So, patent practicing, patent inventing something is different, and practicing patent is different. So there is no law that you should come to us that is mandatory. If you have a valid knowledge, if you interpret and you do know the assessment of the Indian Patent Act 1970, go ahead. No issue with it. But which is not possible. Otherwise, why the Indian government conducts such a Indian patent examinations? We have done this. Why such thing has been conducted? Because that is a very specific practices. You need to know each and everything. Then only you could practice. So, whatever. The writer, ultimately, what you need to care, what you need to take into considerations in order to write, in order to draft a specification. In order to draft a specification, these are the points. These are the points. What is that? First, you need to understand your invention, which is covered in field of the invention. You need to write a single paragraph, the broad field of your invention. It's a quite 1 to 2 paragraph, one paragraph mainly. Then is a very important, the invention belongs to what, that mechanical, and then what exactly is it, pump or water filtration device or what. Second thing is the problem. Writing a patent part is a problem solution approach, man. That is not a thesis writing. No, thesis writing is different. Here the need is problem solution approach. Means what the problem have been identified by you and what are the existing solutions. Now, this is very big. Not existing solutions means, what do you think about existing solution means? It's prior art. Whether do you think that if you file a patent application, your Indian Patent Office is going to examine your patent application in view of Indian document only? Whether the fact is that? No. Your application would have been examined in view of the whole world's document, not non-patent literature. You guys quite, you go through the Google and all, but you do not know how to search a patent literature. Suppose your invention somehow related to a Korean but Japanese person. Earlier, that person's file a patent literature which is published in Japanese language and Korean language. So, if you do not go to the patent literature, you need not to address. It is not possible for you to address such a, although there is a difference, although there is a difference between your invention and that invention, but a small difference, not a big difference. And what was to be considered as your mistake? You did not identify, you did not search that document, I addressed properly in your background part, and the drafting was poor. If such thing is observed now, if such thing is observed or such thing is appeared during examinations, it will be very heinous. It will be killed. Kill means your patent application would have been refused. So all the problem solution approach, when I'm talking about part 2, point number 2, then you need to identify the problem and what are the existing literature. Not Indian point of view, but the whole point of view. Literature including non-patent as well as patent literature, as well as the review article, as well as the oral disclosure, any document, any published document is a prior art for you. Patent office is going to sign. You do not cross them. I have a Indian person, I file an Indian application in Indian patent office. Why you cite a Korean document for my application? No, you cannot raise such kind of voices. It is not allowable. Your application, now your question is, sir, so if this is the interpretation, then why don't you consider that if I file my patent application in India, so it will be considered as a world's patent? I think such kind of questions might have been appeared in your mind. No. Here the problem is patent is territorial. Obtainment of patent in India does not give you automatic patent in America. Okay, but your Indian patent is going to be searched in view of the prior American document. So that is a quite different thing. There is no called world patent. Patent is territorial. So second number point is telling that you need to identify the problem. You need to address the closest prior art, the relevant prior art, and what are the problem? What are the problem deficiency? How such previous technologies is limited? What are the shortcomings? What are the deficiencies? What are the disadvantages associated with such technologies, which are going to be solved by your solutions? Okay, so that thing is point number 2. Point number 3 is that the same thing which I have raised, that is your invention. Claim invention means your invention being published in your journal, any journal before the filing. If it is, don't proceed for patent. If you published your application in even if in your institutional library, institutional journal, not proceed. Don't proceed for your patent application, patent and design. You can proceed for, if such thing is appeared, only solutions in your hand is copyright only. Not patent and design is gone. Now the title part you need to title. One more thing, title is not a big thing in patent. I could show you a number of title, same title. A water pumping, the water filtration device to Mr. X, water filtration device to Mr. Y, water filtration device to Mr. Z. Now every device are different. Title is same. So why how the patent has been granted to different persons containing the same title? Because title, there is no protection in title in patent. Only protection part is claims only. That must be different. So the requirement is your title should be accurate. If you are inventing a water filtration device and your title is a broad, very broad device, water device, so that is not. Filtration word must come. Then this part you need to cover what is the novel in your invention. That part you need to cover what are the basically all the linking part. This problem, the second point is very important, which is the background. Whether you could go through the proper search therapy, so comprehensive search and analysis, then the objective has been derived. Okay, and then once the objective has been derived, then what are your contributions will be coming out. Everything is linking part. Then accordingly, then what are the application? How such objectives which you find out, identify, have been carried out by your invention. The detailed thing should be expected from your patent office is going to be granted your patent only when you fully disclose your invention. If you hide something and that is to be considered as a insufficiency, there is a problem of clarity, then patent could not be granted. So patent, other than the newness, inventiveness, I'm coming on what are the grounds. And then all this experimental data and tables and data, such kind of, if you ultimately 99% patent are improvement. 99% patent are improvement. So what are the improvements? Where the improvement lies, that you need to clear very, very properly. And such improvement, if there is a particular table, a particular graph, which from which it is clearly coming out, okay, earlier is this, your is this. So such kind of data you need to insert in your specifications, such that the person's patent officer or patent examiner controller will clearly understand your invention. Accordingly, they could search. Accordingly, they could proceed for the search and analysis. This is the drawings. The line diagram is allowable, and each and everything should be, each component of this particular in patent should be not a particular numerals on, not any labeling. Okay, if there is outer part, a 10, 7, 9, and this, what is this 12, what is this 13, what is this 14, what is this 15, that you need to keep in a separate text, not in this drawing. Okay, no dimensional features should come in the I think you have a not properly idea the dimensional measurement. I think you fellows are incorporated in the drawings, which is not allowed. Only this kind of drawings with numerals are allowable in the patent. The different, if there is a graph, if there is a particular that flow chart, which is allowed. But devices and in that devices you are inserting such labeling in Word, which is not allowed. Subject matter to grant in India. Do you know what kind of, what are the subjects, what are the subject matter which are grantable in India? Whether suppose if your invention is that direction, that if you made a particular, made an app, if you made a software only, which is allowable in patent, for patent in America, whether you are making a software which is allowable in India in patent? No. India has a certain limitation, certain exclusion in our country. If your invention is purely software, if it is coming out that your invention is a business model, if your invention is purely is a arithmetic equations, if your invention is purely computer, there is no such kind of interaction between the hardware and software. So that kind of subject matter you could not proceed for patenting in India. First thing. Suppose if your invention is that direction, that method of agriculture, I'm not talking about agricultural tools. Agricultural tools means any machine, device for agricultural allowable. But there is a method of agriculture, method of cultivating algae, which is allowable in America, but not in India. Because 70% people in our country are occupations is agriculture. Method is very poor. So when forming the legislature before 1970, for that only they should put certain restrictions in our country. So you cannot protect, you cannot obtain such kind of patent for such kind of invention. So in India, here the design patent, which is quite chalti word in academic era by environment in our country, please be aware that patent and design both are the different act. Obtainment of patent and their scope and their process and their fees is different from obtainment of design. Their process, because the design comes under Design Act 2000, patent comes under Patent Act 1970. Both are the different things. So design patent is an American allowable thing. Design patent is allowable in America, not in India. So in India, you could proceed for a subject matter for either product or process. Certain restrictions are there, but product and process, if you establish that product is new, that product is inventive, and that product is useful. Such subject matter. Okay. So in the title, background objective, which part will give you the protection? Which part will give you the protection? The claim part, which is the utmost important part, and that part should be drafted in such a manner that your protection should not be too broad, that should not be too limited, but narrow. It should be optimal, and that is the beauty of drafting. That is the beauty of drafting. If you are making a formaldehyde, okay, and you are claiming aldehyde, if you are making Solapur and you ask for a Maharashtra, not allowed. Not allowed. Okay. If you invent Solapur, then you should ask for the Solapur also. Other thing should not be come into your face. So accordingly, ultimately, what is the problem? You know that upon receipt of your specification in patent office, due to the unclear drafting, patent official could not in a positions in order to assess a valid search, because the drafting is such kind of problematic drafting, so they could not identify the fence of the text. So okay, we need to go in that direction. This thing that they are claiming Solapur only. They are claiming Solapur only. They are not claiming Mumbai. They are not claiming Nagpur. They are not claiming Pune. They are not claiming Latur. They are not claiming Bhusawal. That thing are open-ended. They are claiming Solapur only. So that is the thing, and that drafting, that is expected from the patent, that expectations of the patent office, that you should draft your claim in such a manner such that they could in a positions in order to assess a comprehensive search analysis. And the claim part, which will give you, I understand you fellows, the academician, ultimately to teach, teaching is the main objective, but tenure of the patent is 20 years. We never know, no? We never know. Suppose today our invention, there is nobody ask us for my invention. But tomorrow our channel is open. Tomorrow I being called by industry for my invention. So tenure of the patent is 20 years. It is, that's why it is not restricted for the 5 years. I understand that technologies, the argument from your end might be in that technology will be modified within 5. That the basicity and the tenure of the technology is 5 years. After that, it would have been outdated. So, but still, why Patent Office, Patent Act will give you 20 years timing? Because of the same thing, that they want you should do the invention in view of the 20 years. So whether your technology will be lasting for 20 years, whether you need to understand all this thing. You need not to invent such thing which is going to be expired within a year, but within 6 months. That is the expectation. We also expect from an academician that because ultimately you have that time. Industry fellow, because ultimately they are the stereotype mind setup, they have a well SOP, accordingly they could proceed. But you fellows, there is no scope for academician. You are open-ended. You could think about whether this technology will be survived, will be stand for further 20 years. That's why it is quite expected from the academicians. They could think in that direction. So ultimately, but doing invention and obtainment of patent for such an invention, both are the different. Doing an invention, okay, very good. Obtainment of the invention, when you would like to obtain, then you should obey the law and rules given by the Indian Patent. Okay, so all these things are the matter. You could see this particular slide. This is a well-settled law. Suppose what is called disclaim. If you are disclaiming something, it means it is open-ended. Suppose a very important parameter in your invention is a dimensional. A dimension is very important. An angle is very easy, and you do not claim that. Okay, claim that means you mention that in the writing part, means before claim part. You mention that in the description part, but it is not mentioned in the claim part. It means it will be considered as a disclaim. And if it is disclaim, suppose there is a copycat. Suppose a third party will come and third party will chura raha in Hindi. So third party will come and they're just doing copying on your invention, and ultimately you will go to the court and raise your voice, file a suit against him. Then judge will ask you whether whatever you are saying that is protected. Your answer should be you, because awareness problem, you will say, yes, sir, I have claimed, I have done the patent, I have the patent. So judge will say, although you have a patent, but that particular feature you have disclaimed. So drafting a claim part is also important. If it is not claim, suppose you miss, if you are missing an important feature, you could not proceed. You could not ask that thing in that kind of situation, in court part, in any infringement part, any litigation part. Understanding the problem. Do you know how the patent office is going to be your invention? I'm just telling you the internal picture of Indian Patent Office. So how once you file your patent application, you got the receipt, you forget it. Right? This is the picture might be. In everywhere, this don't take me otherwise. This is everywhere, which I'm observing since 2011. So once you file the patent applications, first thing Indian Patent Office is going to see whether this invention is falling within the ambit of section 3 to A to P. This is I have very limited time. Section 3 A to P is a particular exclusion. Why? Method of agriculture, software. What is section 3A? That is prevalence. What is section 3B? That is morality. If you are inventing a housebreaking device, if your invention is a gambling device, if you are inventing a what should I say? That kind of bank currency changing device, which is not allowed in India in view of section B. What is 3C? Suppose you find out a particular plant which gives you in Tibet, in Himalaya, which gives you a very tagda, that kind of anti-cancer effect, and you file a patent application saying that you discover a plant. No, that is not allowed. Discovery is not allowed in patent. Section 3D, purely pharmaceutical, means suppose there is a paracetamol, हम खाते हमारे temperature कम करने के लिए, but suppose you come up with a little bit slow single variant of the paracetamol and ask for a patent. Allowable in America, not allowable in India because of section 3D. Section 3E, suppose a fellow will come and saying that, sir, I have prepared a tablet, but I have prepared a lozenge including tulsi and haldi. Okay, so there is no such kind of knowledge. Novelty test is clear, but he will hit at in section 3E because both the substances are known. Both the substances are known for the same use. Suppose he is claiming that anti-diabetic law. So no, that patent will be heated under section 3E. 3F. Suppose you have come up with that such kind of invention that pen cum light. A lighting pen means अंधेरा में आप लिख सकते हो. Okay. Pen is doing his own work, writing work, and light is doing his own work, providing the lighting. Okay. So both the components are doing its work at its own basis. There is no functional interaction. There is no working interrelations. Such kind of invention will be hit under section 3F. So in this view, section 3K means if your invention is purely software basis, there is no hardware and software relations, your invention will hit under section 3K. If your invention, not invention, in that particular thing, I should call that is creation only. So if your subject matter is purely software, don't come for the patent. But don't confuse. If there is the interactions, you believe there is a interaction between the hardware and software, don't consider me in the wrong, don't wrongly interpret that. I will show some cases where it is granted. Suppose there is an app and you are saying that, sir, that is, there is an interaction between the software and hardware. How such kind of patent is going to be granted, I will show. I have such kind of slides. So, understanding the problem means whether the invention is falling within the ambit of section 3 and P. If fall, eliminate. Means there is no need to see any other thing. But if such thing is okay, the invention is not falling within the section A to B. Next part is going to be seen as novelty. Means whether your invention is 100% is matching with any other invention before your date of patent. Before your filing, whether suppose you published your paper and then you file your patent application. At that kind of circumstances, novelty problem, this kind of thing will be appear because your own prior art is hitting your patent applications. That's why, yes, patent office is going to give such kind of objection because novelty is a bar, already I said. Second thing is inventive step. Our inventive step is a big. 2 years is not sufficient in order to make you understand the full concept of the inventive step. Just you have consider this idea means your invention. Suppose in order to take a novelty objections, patent office should give a single document, not multiple documents. Patent office should say your invention, your patent applications, the invention as covered in this particular patent application is 100% match with this document. At that time, novelty objection is there. Okay, novelty objections, your patent office cannot give you a novelty objection in view of the multiple documents. He cannot say, patent office cannot say to this part is coming out from document 1, that part, second part is coming out from document 2, this part is coming out of document 3. So your invention is not novel in view of document 1 plus 2 plus 3. No, that is not allowable for the patent office. For that, they could object such a thing in view of the higher degree of novelty, which is called inventive step. They in a position to raise their voice in that particular ground, not novelty ground, which is another ground, inventive ground, which is called higher degree. Yes, and 100%, 99% killing. There is a 99% killing ground that they in a positions to make a valid objection in view of your application that this part is coming out from document 1, this part is coming out of document 2, this part is coming out from document 3. So combining teaching of the D1 to D2, you are in a position to arrive this invention. Means your invention is obvious in view of the prior document. You need to establish your invention is non-obvious. The requirement is non-obvious, new, non-obvious, and industrially applicability. Means your invention, third criteria, new, non-obvious, Third criteria is utility, means your invention should be used in industry by the industry. So this is the thing, understanding the problem. You first, when you file a patent application, this is the first thing the patent office will proceed in that. Patentability criteria, which I said already, that first thing is new. Newness is gone if you file your invention anywhere before filing a patent application. The criteria is gone. So you don't proceed. If you, publications is also important to file provisional. And then you file, proceed for the publication. I'm coming provisional and complete and what. Second thing is inventive, which is non-obvious. I'm already told you that the first criteria is new. Second criteria is non-obvious, means you need to establish how your invention is technically advanced. Now the question is, sir, our invention is different aesthetically. Suppose it appeared that your invention looks different. You have an aesthetic ground, not technical ground. Would have been sufficient for obtainment of patent for such subject matter. If it is aesthetically good, aesthetically there is an aesthetic creation, and somehow aesthetic effect is there in your invention, you should proceed for design only, not patent. In patent, technical effect, technical advancement need to be addressed properly in your draft. Third thing is usefulness, utility. And fourth thing is your invention should not fall within the ambit of section 3A2. What are the other criteria? Your invention should be clear and sufficient and clear. I can show you a number of applications where these primary criteria are met. Often happen for the academician because they are poor in draft. I'm sorry, don't take me otherwise, which is my observation. There is a newness, there is an inventive step. Your invention has a utility, but you are not disclosing your invention as per section 10.4 and 10.5. And after that, if it is appeared in view of the officer of the patent office, that yes, there is a newness, there is an inventive step, there is a utility, but the disclosure is insufficient, and which is fine. What is going on your brain, not considered. What you put in a specification, your specification is will be you, that is the consideration of the patent office. What is going on in your brain, not considered. What you have put out, what you have put up in your specification, that is the considerable part. So be careful in order to write our patent specifications. Second thing is the unity of invention, means in a single application, single invention is equal to single application. Multiple invention in a single application is not allowed. Means you have a product. I'm coming how. This is the example of unity of invention. This is quite related of, you can consider it in your field also. Process X is for preparations of a product A. Now process Y is equal to process a different process. Is also useful for preparations of product B, a product A. So there is a unity of X and A. There is also unity of Y and A. But there is no unity of X and Y because both are the different processes. So X process, Y process and product A, you cannot file in a single application. You can proceed for X and A for one application and Y and A for the another application. In that case, you need to file two different applications. And that two different applications are different fees, different official fees, different processing, different obtainment, different patent, different protection, with separate protection. So single inventive concept means in order to assess the unity, you need to address and need to draft a claim in such a manner that there must be a unity should exist amongst all the claims. Okay. This is, I think, very useful slide for you. You could proceed for search and through this particular, all these are the free. Suppose you fellows are very useful in in searching non-patent literature in elsewhere and all, but this is my observation. Paid database, leave that you are not, you don't have such kind of database. But what are the free database like this particular, this free patent online is very useful. It comprises US database, EP, WIPO, Japan, Germans, all the important major patent offices are covered. So you can proceed for this particular, this freepatentonline.com. This is useful for searching. Analysis of search. Analysis of search means I don't go, well, I'm not in detail because all this is very fast. Okay, all these are the very fast. I'm just pointing out what is called novelty already I told. You should not disclose your invention before the date of file. Your novelty will be seen. Inventive step, you should come out. You should come to us in such a format that you should, in order to establish the non-inventive step, please satisfy us. Once we satisfy now, this is my experience. Inventive step is clear. Because we do not file your applications unless we got a satisfaction from your end. That you can consider inventive step. Means we again and again we ask for the data, we ask for the where the novelty lies. Is there any angle? Is there any particular dimension? Is there any pressure? Is there any particular arrangement? Is there any particular constructional matter? Is the whether your contributions, what patent office will do? Patent office will take away the existing thing from you, and patent office will give you for your contribution. Patent office will give you award for your contribution, and patent office will take the known part from your end. So inventive step, you need to establish how is, in simple language, how is your invention is technically advanced. Okay. Please read the red part. Need not to address novelties. You need to address the inventive step. Novelty is automatically established. No issue. If you not publish your applications at your own, so not proceed for novelty. Need not such kind of focus is needed on novelty aspect. Inventive, if you focus on the inventive aspect, novelty is automatically met. Because inventive step is always higher degree of novelty. I think you might understand the patent office in a position to raise the voice in view of multiple documents, not single document. So if your invention is novel, that may or may not be obvious. But if the invention is obvious, that is not novel. It is a well-settled fact throughout the world in our system, in patent. Whether the provisional or complete, what is the importance of the provisional and complete? Because if the invention is not complete, suppose some part is yet to be done, but basic skeleton you have, basic concepts, and you have performed. You have performed, some results are yet to come, but you have a fear in your mind that in Kolhapur, such kind of invention somebody is doing. You know that. But for particular results, you should disclose your inventions to a Mumbai persons, a Mumbai company, by any trial test. And for that, you need to disclose your invention. Okay. Such thing in your mind. In that case, you file your provisional, secure the date, proceed for anywhere. Because nobody, if they will file your thing, they will be the loser, you will be the gainer. Because patent is always to be granted to that person who filed first. So provisional or complete by different claims. After filing a provisional specification, you have 1 year time to file a complete. So provisional means If the invention is not complete and you have a fear in your mind, file for the go for the provisional, then you will have a 1 year time to file a complete. But if the complete specification is not filed within a year, your provisional is going to be abandoned. That thing you should consider. What are the difference? Provisional filing is not problematic. It will done within a day or 2 and 3. Okay. But complete specification, what exactly the specification is going to be examined by the patent office? Provisional or complete? Both. But complete specification is a technical law because of the claim part. Claim is regardless in the provision. But claim part is considerable part, and that's why the weightage of complete specification is there. That particular document is considered as a techno-legal document. Provisional is not considered as a techno-legal. That is the provisional. How we generally call provisional means provisional admissions ko kya, complete nahi, provisional ban, interim order. So that means that is not final. Complete is to be considered as the final. Provisional means half. Importance of provisional specification.
Sir, excuse me, sir.
Sorry.
So that provisional is called as an idea patent, or is it similar to that?
Again, the problem is, sir, eliminate such thing from your mind. That is, there is no idea. Please, if your concept is in your mind, okay, although you have not performed that, okay, although I would suggest at least something you need to perform, and then only after that you could file the provisional. But just on the yes, there is an idea in your mind which need to be conceptual is first. Okay, because once you file the provisional patent and after within 6 months you file a complete specification, and if it is appeared in complete specification, 100% is different. At that time, at the time of provisional, you are saying A, B, C, D at the part of your device. Now it is A only, and then there is a G, H, I, J, K, L. So your provisional would not be considered at that time. Okay. So idea patent, there is no particular any correct, any rightful, meaningful. That is, although that kind of thing is going on, I think, yeah, you are talking about this provisional as an idea. I understand, but sir, you need to perform. You should have that concept. Ultimately, concept need to be clear. Then only you file the provisional. Because if it is appear in Indian Patent Office, then provisional specification is a skeleton only. Provisional specific, he just secured the date, the skeleton only of the complete. There the differences, there is a mismatching of the in between the complete specification and provisional specification. If it is appeared in the patent office, it will give you a very, very problematic thing for you in future. So provisional is not a skeleton. After filing a provisional, you could just add on. If there is a B, C, D, okay, C, D, there is a E part, there is a E also, optional, not essentially, optionally, but there is not F. You are not claiming any F part in the provision. You will not cover in that F part in the complete specification. So how do you know if you're not performing? Patent is to be given for a perform thing. Although in India, the concept is quite different as the awareness is concerned, but patent is not to be granted you for an unperformed thing. But if it is not performed, how you are filing a provisional application? Are you getting me, sir? Hello?
Yes, sir. Yes.
So
Yes, sir.
provisional is not an idea patent. For provisional 2, your concept should be ready. And at the time of complete, you just add the technical results. Okay, as a support. Ultimately, why? The patent would have been considered from date of provisional. Provisional में आपने एक चीज लिखा, complete में आपने अलग चीज लिखा. आपको पेटेंट तो प्रोविजनल के डेट से दिया जाएगा ना? कैसे दिया जाएगा फिर प्रोविजनल के डेट से अगर आपकी सब कुछ चेंज हो गया तो? आपके दिमाग में आइडिया आया, आइडिया चेंज भी हो सकता है ना सर? Idea could have been changed. So idea patent, this particular word is not correct. Ultimately, the correct word is conceptualist. You have a fear in your mind. Some invention, your invention is not complete. Correctly बोलिए ना, हम correctly बोलते हैं आज से. Invention, my invention is not complete, but I have to file my patent application because I have some problem. So your invention is not complete and you have a fear in your mind. You need to go to Mumbai for a test, and there could have been stolen the idea, and they could file fast before you, and they accordingly they could call you for a litigation. चलो झेलता बैठो फिर. It's not easy task then in order to fight such kind of litigations and such kind of fight with that fellows. So first thing, if the invention is not complete, you proceed for a provisional. But not complete means you have done something. You have done something, then you come to conclude now that my invention is not complete. So idea patent is not a correct thing. Complete and incomplete is other matter. Claim drafting. Now, these are the three parts that 2-1J novelty inventive step. It should not be fall within section 3 and 4. What is section 4? Atomic Energy Act. If you are dealing some nuclear oriented thing, it would not be granted in India. It's strictly non-patentable. Any nuclear reactor, any zirconium oriented things, any duodenum oriented thing, India will not going to be granted any patent which falls within the ambit of Atomic Energy Act. Section 4. Then your invention should be sufficient, clear, and don't consider it as a chemical or pharmaceutical case. Consider it as a simple apparatus. Simple apparatus. This is my patent. I should not call my patent because I was the inventor of this case. This is granted. Whether you fellows are well aware of Indian Patent Portal website के नाम पता है आप लोगों को? Whether the website of Indian Patent Portal, whether you fellows are familiar?
Yes, sir.
www.ipindia.gov.in. Okay, so
Yes.
yes, that in that particular portal you find out this particular application which is granted, which is a simple apparatus. I'm not going into detail in view of chemistry or chemical. You consider it as an apparatus. So okay, so this is very problematic or hi-fi rocket invention? No. I just put up in a valid way. This is a measuring device. You can consider a measuring device of something. Now, what is the problem? This is the earlier part. This is the prior art. We need to find out this particular art. What is the problem? Durations of mucoadhesion. What is the closest prior art? This Mortazavi et al. 1994. Non-patent litigation. Okay. Now you need to address the disadvantages of this particular apparatus. What are the disadvantages? We mentioned the disadvantages in that field, pictorial. And don't go into detail because you are engineering fellow. Don't going into detail into it. There is a disadvantages we have established before in a specification, and after that we provided our solution, our novel features, and this particular feature is our contribution, and this particular feature incorporated into this part. आपको middle part दिख रहा है? ये दिख रहा है? यही part है, यही part है. So, and this is the full assembly. So in the assembly there is a stirrer, there is a thermostat, all are known. All are known. The functions of each that thing are known. Invention lies in there. This part of it. So you need to address the invention in your write-up in such patent specification in such a manner. What are find out the closest prior art. Try to establish the disadvantages, shortcomings of their technology. Then come to your one. Don't going into the detail because this is the chemical part. Yes. This is another apparatus. This is what? This is a particular thing, an automated apparatus for esterification of a liquid system. अब ये liquid system में मत छी, आप apparatus को consider कीजिए. This is the invention of our inventor. All these patent applications are granted through us. आप देख सकते हो Indian Patent Portal. So this is the inventor, our inventor drawing. Okay. अब इसमें मत जाइए, इतने सारे चीज है. All these are the component of that particular this system. What are the prior arts? You need to identify this prior art. Now this is a Japanese document. The closest prior art of our inventor means he belongs to Nagpur, so Indian. And this particular technology, जो relevant था उनके केस के लिए from Japan. This is the Japanese document. This is the Japanese document. So you need to identify such a document. Then talk about the disadvantage of the technology. In particular, it is also the liquid esterifications of the liquid system, but it using an additional distillations unit, which is this orange highlighted, which is not needed in our invention. Yes, patent would have been granted. Mean in order to achieve a same purpose, you are not using any essential part of earlier one. That means there is something different in your case. A, B, C are needed in order to achieve D. Okay, A plus B plus C is equal to D. That is my one. Now you come up with A1 plus B is equal to D. No need of C. So that is the invention. So if your invention is in that direction, that lies that in order to achieve a same purpose, you are not using, you eliminate a need of a particular essential component. Distillations unit was essential in this particular esterification system, but this particular, our inventor was done esterification in such a manner that different separate distillations unit was not needed. Simple. टिपिकल इंजीनियरिंग में मत कंसीडर कीजिए इसको. सिंपल है. हमारे घर पे जो ग्रांट मॉम है ना, ग्रांट मॉम का इन्वेंशन, फूड बनाया उन्होंने. क्या किया है? ग्राइंडिंग ग्रेन बेस्ड, मतलब प्रिपरेशन ऑफ इंस्टेंट पोट्रीज उन्होंने ग्राइंड किया, मिक्सिंग किया, रोस्टिंग किया पर्टिकुलर टेम्परेचर. ओके. Now the questions might have been considered, sir, it is granted. Yes, it is granted. Sir, क्या घूस खिला के grant हुआ? No. Merit पे. How? Merit established नीचे है, existing knowledge में. These are the prior arts. This US documents, European document, and Chinese document. You also the saying the instant portraits, preparations. Okay. But in this particular document, they are using multiple time of heatings. Multiple time of heating, and our ingredients are the natural based. We are not any chemicals. Our ingredients are the natural based. If we are using so many heating steps as a heating purposes for the natural substances, the nutritional property and profile would have been gone. Our invention is have an edge. Our invention has an edge in view of that. We have a single heating treatment, not multiple. So they are suggesting multiple heating. We are using single heating. Teaching is different. Teaching is different. That is the thing. Suppose if for inventive steps, such kind of argument is very useful. Suppose they are suggesting a non-polar solvent is very important, like chloroform. In order to achieve, they are saying the dielectric constant of this non-polar solvent is very useful in order to achieve the purpose. And you are using water for same purpose. How? The teaching is contrary. Now, ultimately, you would like to reach that part on. only, but different way. हमें सोलापुर पहुंचना है, हमें सोलापुर पहुंचना है, तो हम पुणे पहुंचे और पुणे से भी सोलापुर पहुंचे. This is suggested by Mr. A. Okay. Now मैं सोलापुर पहुंच रहा हूं, कोल्हापुर होके. My teaching is different. मुझे भी पेटेंट मिलेगा. Although my patent is disadvantageous because ज्यादा टाइम लग रहा है, ज्यादा खर्चा हो रहा है, ये सब है. But मैं एक different, not falling with his teaching. आपको वो establish करनी है आपकी पेटेंट स्पेसिफिकेशन में, जो you are not following the teaching of previous knowledge. अब समझ में आ रहा है डिफरेंस कहाँ है आपके रिसर्च आर्टिकल के साथ हमारी पेटेंट का स्पेसिफिकेशन राइटअप का. वहां पे आप ब्रैकेट में लिख देते हो ना जो कौन सी टीचिंग से आप मोटिवेट हुए हो. इन ऑर्डर टू राइट अप रिसर्च जर्नल आप लिखते हो ना ब्रैकेट में जो पीटरसन एट ऑल 1993, which is you should not do in our patent specification. You should consider some references, but your contribution, what is your contribution, that should not be drafted in such a fence, but such a practice. Such practice is wrong. ये आपके फील्ड में है, सिविल में. ये महामेट्रो नागपुर का पेटेंट है, हमने किया था. देखिए तो डिफरेंस क्या है, ऊपर का प्रायर है और नीचे का इन्वेंशन है, मतलब ग्रांटेड. What are the differences? I think civil peoples are here, right? Dr. Mane.
Yes, sir.
Whether civil peoples are there, civil engineering peoples.
Yes, yes. They are there.
Yeah. So now I think they might understand what are the differences. Okay. So this is, you need to identify this prior at first. Then after searching that prior, that disadvantages of such a prior you need to address properly in your background of the patent specification. Then only it will be clear to the patent office, okay, these are the differences and this is his invention. What is that? Innovations made due to these differences. This is the earlier one, prior, and this is the Mahametro. This is granted recently. So innovations made is where reduce the width of the box girder, width of this reduced DA means that design load कम हो रहा है. Then reduced DL, SIDL कम हो रहा है इस टाइप का डिजाइन में. फास्टर कंस्ट्रक्शन है, सेफर कंस्ट्रक्शन है, ये सब है. ये आ रहा है इस पर्टिकुलर डिफरेंसेस के कारण. And that differences, so first, what is the requirement first? First requirement, you need to search this particular product. After that, you need to point out the point of differences between that and this, your one and that one. After that, you just all the how this is disadvantageous, you need to address, and how the disadvantages are overcome by your invention, that you need to insert in the detailed description in very prominent matter, and after that we just claim. This is the claim part. Okay, now claim part I do not mention here. This is another civil invention. Are compositions useful as alternative filling material for hydraulic stowing process in underground mine? There is a company, government company called as Moil Limited in Nagpur. The invention granted, this invention is from, belongs to them. So there is a composition. What is the composition? Overburden material in the particular diameter. Then the same material of different, a sand, a gypsum, all these are the known thing. All these are the known thing. But invention in the particular selection. A is known, B is known, C is known, and D is known. Sir, all the ingredients are known, but we are using a particular concentration. And we have a synergy. We have a data which clearly establishes other concentration are not used. The advantageous effect and surprising effect are only obtained if we combine these ingredients A, 1, 2, 3, 4 in such a direction, in such a manner, then only the advantageous effect arise. Otherwise not. If you establish such a thing, it will be considered as a selections pattern. And selections pattern is allowable in India and anywhere in the world. Another civil oriented thing means, I mean to say, if the ingredients are known, but your invention lies in a particular selection, particular concentration, particular combination, you can proceed. You provided you should have a data. I'm sitting in a legitimate learned forum, but now I'm talking to you. Patent invention belongs to 10th pass person. His qualification is 10th pass only. Okay, who is the inventor of this? A process for producing methane gas from running wastewater. आप लोग एक डिबेट सुनते होंगे, मतलब काफी इन पर्टिकुलर दिस टुडे सिनेरियो, जो नाले से चाय बनाते हैं, काफी चर्चा चलती है. वो इन्वेंशन यही था. वो रॉन्गली इंटरप्रेट हुआ पूरे होल इंडिया को. क्यों नहीं बन सकता है? एंड दिस वाज द पर्सन, द सैम राव सिर्के फ्रॉम छत्तीसगढ़. इन्होंने वो चीज किया था और उन्होंने एस्टेब्लिश किया था इन ऑर्डर टू अचीव. हाँ, अब वो 10th पास है, वो पर्टिकुलर कोई इंजीनियर नहीं है, तो पेटेंट फाइल नहीं कर सकते. देयर इज नो पर्टिकुलर एनी क्वालिफिकेशन नीडेड फॉर पेटेंट फाइलिंग. नो नीड. If you are 4th pass, if you are 5th pass, but you establish, but you met with the requirement of Indian Patent Act 1970, qualification is regardless. But hota nahi hai. This Sam Rao Singh also associated with IIT Madras and all. Then only that thing is arrived. So, जो इन्वेंशन है वो ये है, a non-electric process. Ultimately, there's a various. If you establish that your invention is so cost effective, no need of use of any manga instrument and apparatus and costly process and steps are required in order to achieve the same thing. In order to achieve same thing, electricity is not needed. Pressure, such kind of pressure container is not needed. Such kind of space is not needed. Such kind of compressor is not needed. I arrange the component in such a manner that there is no need of electricity. There is no need of compressor. If you establish your invention in such a manner, and if you convince the patent officer, patent will be granted. ये उसी केस का एग्जाम्पल. वो गलत इंटरप्रिटेशन पूरे होल इंडिया में हुआ है, जो नाले से चाय बना दिया. क्यों नहीं बना सकते भाई? बिल्कुल बना सकते, बिल्कुल बना सकते हो आप. If you are opposing this invention, तो you should come properly. अब आइए बिग ओपोनेंट, अब आके इसको अपोज कीजिए, तब तो आप आए नहीं हो भाई. Patent, giving a patent certificate, what do you think? The giving you a patent certificate means उसको क्या कोई रोक नहीं सकते? There is no validity, patent validity given by the patent office. Patent office आपको patent certificate दे रहा है in view of उनकी search, reasonable search and examinations के basis पे. और patent की validity दे सकता है 20 साल के लिए आपको. Means कोई भी opposition नहीं कर सकता आपके patent में after grant. ऐसा कोई भी patent office, India नहीं. Whether any patent offices of the whole world will give you a validity certificate? No. अगर देते तो पोस्ट ग्रांट ऑपोजिशन, रिवोकेशन प्रोसीडिंग, ये सब प्रोविजन क्यों है? वो उनकी जो सर्च, उनके जो एनालिसिस, उनकी जो एग्जामिनेशन है, उनकी बेसिस पे पेटेंट दे रहे हैं. आपको अगर रोकना था तो आप प्री ग्रांट ऑपोजिशन में आ जाइए. देयर इज टू टाइप ऑफ ऑपोजिशन, प्री ग्रांट, पोस्ट ग्रांट आल्सो. You should follow each and everything. You should come to the patent office with the relevant provisions and rules. आपको कहीं पे आना नहीं, कुछ करना नहीं और सब बातें करना, ऐसा नहीं चलेगा. So this was the invention. The advantage of this invention was non-electric process. First, अब एक डेंटल डिवाइस है, आप लोगों को इसलिए मैं दिखा रहा हूं, डेंटिस्ट्री में मत चाहिए, डेंटिस्ट्री में मत चाहिए। अब डिफरेंसेस देखिए तो ये होता है ना, ये अपना वर्नियर कैलिपर, एक सेकंड, ये एग्जिस्टिंग डिवाइस, दिस इज व्हाट आर द डिफरेंसेस बिटवीन दिस टू डिवाइस, क्लोजेस्ट पैरेट के साथ ऊपर का जो डिवाइस है कहाँ डिफरेंट है, आपको खुद ही समझ में आ रहा है। इन द वन साइड देयर इज नो होल, हियर इज अ होल, इट इज फिक्स्ड, इट इज डिटैचेबल। ओके, तो सर इसके लिए पेटेंट दे दिया। Teaching is that below part and above is the new column. Inventor contributor. आपको ड्राफ्टिंग उस तरीके से आना चाहिए, इस तरीके से क्लेम को लिखना पड़ेगा। सर ये हमको नहीं आता, आई एम सॉरी, दैट इज आवर ब्यूटी एंड आवर स्किल टू विज form a claim in such a format which is the need. So आपको ये देख के ये बहुत डिफिकल्ट लग रहा है, जो बहुत डिफिकल्ट होता है पेटेंट, मुझे तो नहीं लगता, ऐसा नहीं लगना चाहिए, बिकॉज दिस इज द प्रायर एक्ट एंड दिस इज द न्यू वन। यहाँ पे होल नहीं है, यहाँ होल है, यहाँ नहीं है, ये डिटैचेबल नहीं है, फिक्स्ड है, और डिटैचेबल। So another case for water heating and cooking device, mechanical case, ये है वो डिवाइस। सर इट इज ग्रांटेड, यस, आप देख सकते हो इंडियन पेटेंट पोर्टल में ये एप्लीकेशन नंबर डालिए, आपको मिल जाए। तो सर क्या है इन्वेंशन? इनलेट, आउटलेट, बर्नर, वाटर टैप, कैरियर क्रीट, बकेट। 2008 के पहले नोन नहीं था क्या? Questions might be appear in your mind. I'm talking to mechanical people here. Questions might be appear in your mind. भैया इन्वेंशन वहां नहीं है। Invention lies this particular part, characterized after part of this, characterized in that. It is the improvement, means before that characterized in that part unknown, I am admitting. But after that part, this is the claim draft. If your invention is a improvement, then you should write a claim in such a form, so that patent officers clearly understand this part is not known, and this is known, and this is not, so that they will conduct a search for such not known part. If they not find out that part, they should consider that is inventive part. So this inlet, outlet, burner, capillary tube, carrier grid, and bucket, the arrangement is the invention. Existing art failed to suggest this particular feature. This is this water heating and cooking device. मैं आपको एक इन्वेंशन बताता हूँ। ह्यूमन एनर्जाइज फोडर चॉपर, ये है वो इन्वेंशन, फाइल इन 2010। सर फिर क्या है इन्वेंशन? टू कंस्ट्रक्ट अ मशीन फॉर कटिंग द फोल्डर इनटू स्मॉल पीसेस विद अ रिड्यूस्ड ह्यूमन लेबर। आप कोई मशीन अगर बनाओगे उसको कुछ भी काम करने के लिए, आप अगर ह्यूमन लेबर को कम कर रहे हो, आप अगर आपके खर्चा कम हो रहा है, मैनुअली कर पा रहे हो, आप एनवायरमेंट फ्रेंडली है आपका इन्वेंशन और मशीन, आप सिंपल है, इतनी कॉम्प्लेक्स नहीं है आपकी इन्वेंशन। ओके, आप अगर इस चीज को प्रूव कर पाते हो, एंड हाउ, ये आंसर है हाउ। तो सर क्या बाइसाइकिल के अंदर पेडल चेन और फ्री व्हील ये नोन नहीं था 2010 के पहले? पेयर ऑफ गियर 7 और 10 नोन नहीं था 10 के पहले? फ्लाईव्हील नोन नहीं था 10 के पहले ना? एक ये प्रोसेस यूनिट मतलब कटर, ये नोन नहीं था 10 के पहले, 2010 के पहले। ऑल आर नोन, इसलिए तो हमने कैरेक्टराइजेशन दैट के पहले लिखा। इन्वेंशन लाइज इन दिस पार्ट, दिस आफ्टर पार्ट। आपको नीड टू construct a claim, such a construction that patent office will clearly understand your invention. It's a simple machine for cutting fodder into pieces, granted in India. आप पेटेंट पोर्टल में देख सकते हो। This is the electronic oriented thing, computer related invention, a system for multimodal, multi-route public and private transportation commuting system. It is also granted in India through our hand. इस तरीके से आपको लिखना पड़ेगा, आपको ऐसे फ्लो चार्ट देनी है, आपको फ्लो चार्ट देना पड़ेगा. दिस इज द इन क्लेम्स कंस्ट्रक्शन इस तरीके का रहेगा. अब दिस इज वेरी क्वाइट लिमिटेड टाइम टू मेक यू aware about the implication of section 3. For that we need to spend at minimum 2 days in your campus, then only I think. It's not possible to make you aware. Just understand if your invention, yes, this is the app based invention, where the software and hardware are considered as a combined feature, then only it is granted. Yes, this is the example. This is the example. You could go this kind of drafting for an app. यहाँ पे कहीं पे ऐप मेंशन है क्या? ऐप ही है ये. हमने कहीं पे ऐप लिखा है? नहीं लिखा ना, सिस्टम लिखा हुआ. This is system. Means you can, that is a way of drafting. Another section 3K case, a system for real-time detection of internal and external power theft in electrical power distributions system. In electrical चोरी होती है ना, इंटरनल एक्सटर्नल थेफ्ट का एक प्रॉब्लम होता है इलेक्ट्रिकल ऑफिस में, इलेक्ट्रिकल पावर डिस्ट्रीब्यूशन में, उनके लिए एक सिस्टम बना दिया. इट्स वेरी वेरी यूजफुल फॉर द गवर्नमेंट यूज. इट इज आल्सो ग्रांटेड. इट इज आल्सो ग्रांटेड. सो आपको लिखना पड़ेगा इस तरीके से. जो क्या आईओटी बेस्ड कम्युनिकेशंस नेटवर्क नोन नहीं था सर 2021 के पहले? नोन था ना. मास्टर मीटर नोन नहीं था, नोन था ना. वहां इन्वेंशन ही नहीं है. कौन कह रहा है वहां पे इन्वेंशन है? ये सर इन्वेंशन कहाँ है सर? पे ये वेरिएंस. सर अभी हमको ऐसा लिखना नहीं आएगा, वो हमारी गलती. आपको either you should adopt such a practices if you would like to do. मेरे पास ये कॉल नहीं आना चाहिए कभी भी. तो सर हमें हमारा इन्वेंशन था, पेटेंट ऑफिस ने गलत तरीके से रिफ्यूज किया. ऐसा नहीं हो सकता. हाँ गलती करते हो लोग, बट अच्छी ड्राफ्ट करने के बाद अगर गलत वो लोग कर रहे हैं तो उनकी प्रॉब्लम. बट मोस्ट ऑफ द केसेस में ये देखा गया हुआ है कि ड्राफ्टिंग वाज नॉट गुड. आपको इस तरीके से लिखना पड़ेगा, इस तरीके से डायग्राम देके एस्टैब्लिश करना पड़ेगा जो where the invention lies, because 99% are known. There is a very thin line differences between the previous one and your one. So that thin line difference should come up in such a clear manner. The 1% which is sitting in the patent office, and what do you think that? Suppose you are a mechanical engineer and your hardcore is water filtering, water purification is your subject. Water purification. So what do you think? Suppose you file an invention in the Indian Patent Office, a person, patent officer, whose it's not necessary to allot your case to such an officer who belongs to same field, means water filtration, but water purification system. Suppose आपके invention ऐसा कोई persons को गया, वो mechanical का है, but अलग है, not water purification में उनकी कोई उतनी mastery नहीं. मैं एक pharmaceutical वाला हूँ, तो मैं इतनी बातें क्यों कर पा रहा हूँ? ये सारे पेटेंट मेरे हाथ से हुआ ही कैसे? ये जो चॉपर मॉपर ये सब हुआ कैसे? इलेक्ट्रिकल पावर डिस्ट्रीब्यूशन उतनी जरूरत नहीं है. Don't consider this as a Pascal, Archimedes and Einstein. We do not need such kind of theoretical thing from your end and such kind of thing from your end. We just need to know what is previous and where are you? What is yours? That's it. This is the processing. This is the processing of the patent application. I think you might know there are two types: normal route and expedited. Okay. So first thing is to conduct a search. Then you file a patent application. If it's not complete, file a provisional. Then complete. Then you accordingly 18 months your patent application will hide. But if file the form published within a month, don't consider that publication as a grant. That is a previous grant, there are two type of publication. Before grant, after grant. Okay, so before grant publication, that is not a grant. This is routine procedures of patent office. Okay, expedite procedures, and then the patent office will examine, give you the examination report. You need to file the reply to the examination report within 6 months. Okay, if they satisfy. Now the point comes. If they satisfy, they will grant. 80% cases में वो लोग satisfy नहीं होते. They ask for the hearing, for the outstanding objection. Then you need to attend such a hearing. Need not go to the patent office. आपके कैमरा होगा, आप कंप्यूटर में कर सकते हो. Then you need to file a hearing reply within 15 days. Okay. यहाँ पे कहीं पे भी डेडलाइन आप मिस करते हो ना, वो पेटेंट ऑफिस नहीं सुनेगा कि आपका तबीयत खराब था, कि आपके कॉलेज में पढ़ाना था, कि आपका नैक था, आपका एमबीए था, तो कोई कुछ नहीं सुनता होगा. आपको पेटेंट मतलब ही टाइमलाइन आ गया. आपको अगर कोई चीज को कुछ एडजस्ट कराना है तो वो ड्यू डेट जब तक एक्सपायर नहीं हो रही है उससे पहले कीजिए. और कोर्ट प्रोसीजर्स और पेटेंट प्रोसीजर्स में डिफरेंस है, उतनी एडजस्टमेंट हमारे लाइन में नहीं होता. Okay, so this is the procedure. Expedited procedures were very good for Indian female now. I'm sorry for the male guys that suppose Mr. X, Mr. Y, Mr. Z, all three males are the inventor. And if they could expedite their patent application in India, no. Mr. Y, X, Y, and Z, out of three, one must be misses, miss. Sir, ऐसा क्यों? Male के साथ ऐसा problem क्यों? ऐसा हुआ है. जो one applicant should be female. If there is a single female, वो लोग expedite कर सकता है. But आप लोगों को एक आध female को लेना पड़ेगा, तब जाके आप expedite कर सकते हैं. सर, हम लोगों के कॉलेज से अगर फाइल किए तो आपके कॉलेज प्राइवेट है ना पब्लिक है, गवर्नमेंट है? Am I audible?
Yes, sir.
आपके
It is
कॉलेज
private. It is private.
प्राइवेट कॉलेज में आप नहीं कर सकते. सोलापुर यूनिवर्सिटी कर सकता है एक्सपीडाइट. सोलापुर यूनिवर्सिटी could expedite the process. आप आपके कॉलेज के नाम में नहीं कर सकते, एक्सपीडाइटेड नहीं कर सकते. हाँ, कर सकते हो. Then you file your international patent application through PCT route. Then come through that way, which is very costly. अब तो आपके कॉलेज के मैनेजमेंट नहीं देगा. I am sorry, which is my observation. So आपको अगर एक्सपीडाइटेड करनी है, आपको अगर 1 साल के अंदर पेटेंट चाहिए, तो आपको इंडिविजुअली फाइल करना पड़ेगा. 2 लोग एटलीस्ट, 2 लोग, और उसमें से एक फीमेल होना ही चाहिए. तो सर ये तो प्रॉब्लम है हमारे देश में, या बोलोगे तो सर don't raise these questions in front of me. Ask our government of India, Ministry of Commerce and Industry Ministry, because this is the rules. Okay, there are other criteria which are not. I think you are not MSME, you are not startup. हाँ, startup MSME के लिए expedited. आप लोगों के लिए सिर्फ फीमेल एप्लीकेंट वाला क्राइटेरिया बैठेगा. Rest of the procedures are set. Listen, there is no patent shall be granted within 6 months from not date of filing, that is date of publication. 6 months minimum waiting, mandatory waiting period. Means what? That suppose to agar 6 months nahi dega, then how a third party will oppose your application? So this is the minimum mandatory waiting. 6 months तक कोई भी पेटेंट ग्रांट नहीं होगी डेट ऑफ पब्लिकेशन से. अभी मैं आपको एक पेटेंट दिखाने जा रहा हूं. The rules is no patent shall be granted within 6 months. पर 6 months one day में तो हो सकता है ना? हो सकता है ना?
Yes.
6 months one day में पेटेंट हो गई. From Solapur University. 6 months, this patent has been granted in 6 months one day. I don't consider it as ideal. But होता है, मैं आपको सिर्फ यही दिखाने के लिए कोशिश कर रहा हूं that it is possible in today's scenario. You also see that out of 2, one is lady, one is female, Dr. Fadnavis. Okay, so patent is in this mechanical engineering. Now the we need to come. Suppose once your application is refused, erroneously refused by the patent office, then what option you have? You have 2 options. One option is you need to file a review petition or you need to go to the High Court, High Court for filing appeal. रिव्यू पिटिशन का एडवांटेज ये है जो थोड़ा कम खर्चे में होते हैं, प्रोसेस थोड़ा फास्ट है, बट जाएगा वो पेटेंट ऑफिस में ही। और सबसे बड़ा डिसएडवांटेज रिव्यू पिटिशंस का वो है कि इट विल गो टू द सेम कंट्रोलर जिन्होंने आपकी एप्लीकेशन रिफ्यूज किया। द चांसेस ऑफ गेटिंग सक्सेस इज 1%। 99% केसेस में मैं मेरी डिसीजन को कैसे अलग करूं? आई एम टेलिंग राइट नाउ दैट यू आर फेल, you are challenging, and after that, after 2 days, I will say, no, I have done a mistake. You are qualified person. मैं ऐसा नहीं बोल सकता हूँ ना, नहीं तो मेरे ऊपर प्रॉब्लम आएगा जो मैंने क्या असेस किया। सो 99% केसेस में उनकी डिसीजन चेंज। रिव्यू पिटिशंस का सबसे बड़ा प्रॉब्लम, दैट इज द अटमोस्ट डिसएडवांटेज, दैट उतना स्कोप नहीं आपके पास। कोर्ट का एडवांटेज, जज विल कोर्ट द पेटेंट ऑफिसर। पेटेंट ऑफिसर को पूछा जाता है जो आपने ऐसा गलत डिसीजन क्यों किया। मोस्ट ऑफ द केसेस में देखा गया है दैट पर्टिकुलर आफ्टर द कोर्ट consider the matter, the case is revert back to patent. Disadvantage is it's a costly procedure and it's also time consuming matter. अब मैं आपको वो दो केस दिखाने जा रहा हूं, one is court case after the refusal and one is review petition. मैं आपको क्या बोला, तो only 1% chances is review petition, but percentage तो है ना 1. This is a case. अब देख लीजिए, now it is granted. It was refused. This is our case also. Now it is granted. There is two different decisions of different official. मैंने आपको क्या बोला, it should go to the same controller. Why then? The questions might have been appear in your mind. Why these two different offices? Because patent office itself acknowledged there was a mistake from their end. That's why they reallocated this case to another controller, and then only it has. This decision of 10 June 2021 is refusal. And this 7 September 2023 is granted. This is a review petition case, but don't consider it as an ideal. Because मुझे क्या-क्या करना पड़ा था ना इस केस में मैं जानता हूं. Don't consider it as an ideal, but ऐसा होता है. This is the granted claim. This is a simple sterilizing critical. This is although life science oriented case, but I'm giving as an example. Now, this is mechanical engineering. One of our clients, Mr. Mukesh from Uttarakhand, developed a combustion apparatus for a diesel engine. For a diesel engine, not for a petrol engine. We have done each and everything in so nice manner, but unfortunately, patent was refused by an officer, belongs to Chennai Patent Office. Okay. Now, this Mr. Vidyarthi went out for the court for appealing. हमने कोर्ट में ये फाइल कब हुआ था 2018 में, डेट 18 देखिए कब फाइल हुआ 18 में. हम कोर्ट में कब गए, and Delhi court says that ये लाइन को पढ़िए, डायरेक्शन first point, the impugned order dated 12 December 2019 is set aside. Means कंट्रोलर डिसीजंस को कोर्ट ने खारिज कर दिया. ये इसको रेफर बैक बोला जाता है. इस केस को रेफर बैक उन्होंने हियरिंग देने के लिए बोला था हाई कोर्ट ने, बट अभी भी पेटेंट ऑफिस ने कोर्ट की ऑर्डर नहीं मान रहा है. ये पेटेंट 2018 में फाइल होने के बाद, कोर्ट प्रोसेस होने के बाद अभी भी ग्रांट हुआ नहीं है, मतलब सर्टिफिकेट नहीं आया. इतना टाइम चला. सो यू आर नाउ, दिस इज द 1 March 2024 decision. Okay, this is the pending claim. You just look at the preamble part of the claim. This is absolutely for a diesel engine. This invention related to diesel engine, which we argued in very firm manner that whether petrol engine or diesel engine are same. If it is same, then why the different pumps but different nullies are available in the petrol pump? जिससे आप पेट्रोल देते हो उसी से डीजल दे दो. बहुत ही clear case था, but unfortunately this case was refused, and the applicant went to the Delhi High Court. But time consuming matter. Refusal or withdrawn claim. ये पहला फार्मास्यूटिकल है, but means रिफ्यूज भी होता है और ऑपोजिशन होती है। आप अगर जब झूठ बोलते हो ना, इफ यू आर टेलिंग लाई, इफ यू आर टेलिंग सम फ्रिवलस थिंग, आप कैसे पकड़े जाओगे पता है? इस केस को देखिए, इट्स अ टिपिकल फिजिक्स बेस्ड केस। फॉर दैट वी आर द ओपोनेंट, हम लोग ओपोनेंट थे। We file our representation in view of ये ground पे wrongfully obtaining novelty, obviousness, utility, frivolousness, morality and atomic energy। अब बहुत sincerely and closely देखिए एक चीज को। This is the figure 1 of this patent application, means this is their claiming. This process ultimately claimed by the applicant of this application. Look at the figure 1 very clearly, very properly. देख लिया figure 1? This is the figure 1 of earlier one, means prior art. आपकी फिगर 1 ही मैच हो रहा है, मींस आपका जो फ्लो चार्ट है उसका ईच एंड एवरीथिंग इज मैचिंग। इट मींस इट्स अ कॉपीकैट। अब पकड़े गए हो। दिस पेटेंट वाज आफ्टर फाइलिंग दिस ऑपोजिशन, applicant withdrawn this case. If you go through the Indian database, you just clearly see that the status is withdrawn, means I am blaming you, the US, I'm blaming you. And but I am, what should I have blaming you? आपने आपकी चीज, आप कुछ भी नहीं कह रहे. You are not answering, you are not replying to my each and everything. It means you are admitting you did that. This was the case of that. There's a very other grounds also there, that 100% copy paste. There's other ground we raise and we hit their invention in that way too. So conclusion is, if the one seems to be master of the copy paste, might succeed sometime, but not always. पकड़े जाओगे आप. So these are the mistakes done by you fellows. These are the mistakes. मैं इसको पढ़ना नहीं चाहूंगा, आप ही देख लो आप लोगों के मिस्टेक्स क्या होते हैं। वही जो गूगल सर्च करके आप पता कर लेते हो, जो बस मेयर मार्केट सर्वे, आफ्टर दैट यू कंक्लूड दैट योर इज पेटेंटेबल वन, whether the pre-filing is done, whether all the assessment are done, how the claim are brought for you, drafted by your attorney, whether Form 9 के सभी केस में फाइल करना है, मतलब अर्ली पब्लिकेशन सभी केसेस के लिए एप्लीकेबल है। अगर एफआईआर इशू हो रही है तो whether your patent attorney, अल्टीमेटली यो हो सकता है जो मैं आपके फील्ड का नहीं हूँ, तो मैं एस्टैब्लिश कैसे करूंगा इन्वेंटिव स्टेप बिना इनपुट लेके आपसे? विलिंगनेस नहीं है आप लोग रिन्यूअल नहीं भरते हो टाइम पे, then Form 27 भी नहीं भरते हो, which is mandatory. Whether your invention is commercially worked or not, that information should have been provided, must have been provided to the Indian Patent Office once in a 3 years. It's must in today's scenario. Otherwise 10 lakhs का एक मतलब offense wait कर रहा है, जेल भी है. These are the mistakes. These are the recent amendment. जो सबसे इम्पोर्टेंट ये फॉर्म 3 में you fellows are not filing the foreign application, इसलिए उतना ये नहीं है. तो मेजर वो है जो 48 month to 31 month, means earlier if you file the patent application form 18 14 48 months का डेडलाइन रहता था, वो अभी 31 month का. पर हाँ आपको एक अलग से ही सर्टिफिकेट ऑफ इन्वेंटरशिप मिल सकता है पेटेंट ऑफिस से, इंडियन गवर्नमेंट से। ये सब है रिसेंट अमेंडमेंट। All these are the amendments. Thank you very much. If you have any queries, any doubt, we have 20 minutes time to discuss.
Yeah, thank you very much, Mr. Roy, for this wonderful session on the IPR. So now the session is open for the question and answering. If any participants or faculties have doubts, then you may ask to the expert.
Talk to me. अब घबराइए मत, आराम से आपके क्वेश्चंस को पूछिए।
Good afternoon, sir.
Good afternoon.
Sir, I'm a student from MIT. I am from Computer Science Department. My name is Afro. Sir, me and my friend Prathamesh Patel from Mechanical Department, we were to try to file a patent, but we had a few questions to you. So can I start with it?
Yeah, please, but your sound seems to be unclear. I don't think any technically that is interrupted. Yes, yes, come again.
Give me a minute. Now, can you hear me?
Yes, yes, I can hear. It's clear now. Yes, tell me.
There's a little bit of echo because. So I had a question that can an idea be patent? Can an existing software system be patented? What are your thoughts on it? Can an existing software be patented?
If it is purely software, don't go for any patent filing in India. If it is purely software, but if there is a matter of some software and hardware combined feature, okay, if that is a matter of combined combinations of hardware and software, then that is a subject matter. Then that is a subject matter for patent filing, provided novelty inventive से देखना पड़ेगा. But आपको अगर purely software है तो आप पेटेंट मत करवाइए, कॉपीराइट ही फाइल कीजिए. If it is pure software, but if there is a particular app and all, and that app part which I have shown you, that app, don't say it is app in writing. You just say it's a system. And there must be in that system, there is a combinations of hardware and software. And there is a specific interrelations of that particular hardware and software. Then only whatever we want to achieve is arise. Otherwise, not. If we are not combining hardware and software in such a manner, which we are claiming, the advantageous effect would not be arrived. मतलब हार्डवेयर एंड सॉफ्टवेयर को आप जिस तरीके से जोड़ रहे हो वैसी जोड़ना है, अदरवाइज जो आप चाहते हो आपको कभी नहीं मिलेगा.
नहीं सर, वो TCS का हमने पेटेंट्स देखा था, but in that one patent was there of a recommendation system. So how is it connected?
अरे बाबा, तो रिकमेंडेशन सिस्टम उन्होंने जो ये किया है, फाइल किया है, वो उन्होंने एस्टैब्लिश किया होगा जो देयर इज अ रिलेशन बिटवीन द सॉफ्टवेयर एंड हार्डवेयर. Purely the final effect, the reasons behind such a that effect, the reasons not 100% due to the software. उन्होंने ये एस्टैब्लिश किया होगा जो कॉम्बिनेशंस के कारण ही उनको रिजल्ट्स मिले. ये हो ही नहीं सकता. If it is appeared that final effect is the result, final result is just because of software, तो उनको पेटेंट नहीं मिलेगा. इन अमेरिका में मिल सकता.
If not the software or the system, then what can we patent the process on which it is working?
आप एक काम करो, आपकी राइट अप बना लो और आप मुझे ना एक समरी करके भेजो. इट्स अ वेरी क्रिटिकल थिंग फॉर असेसमेंट. we cannot say merely. Ultimately, after go through all the document, I think it will be clear to us to, yes, it is purely software. Then only we can suggest. We can suggest to why don't go for copyright only. But if it is appeared to us that okay, so there is a combination of hardware and software, then accordingly But we will be in positions to provide our opinion once we will go through properly your case.
Okay, sir. We are already we are doing the writing work. We are trying to.
जब भी हो जाएगा तो भेज दीजिएगा हम देख लेंगे.
Okay, sir.
Anything else?
Sir, there is one more question. That is whether the design and utility patent holds equal importance, because
Hello. Yes. Am I audible? Yes, Dr. Mane. Am I audible? Hello. Hello.
You are audible,
am
sir.
I audible, sir?
Yes,
You are
sir.
audible, audible.
Yes, sir.
Yeah.
Just a minute, sir.
I think network issue, that's why. So my question is whether the design as the utility patent both holds equal importance.
Equal importance, importance are in view of the different aspect. Means, suppose if your invention is not patentable, means somehow it is obvious, you also believe, then don't proceed for patent, proceed for design on. Okay, design patent and utility patent, both are the different thing. Design, not I'm sorry, design registrations in India and utility patent in patent are the different. वो आपके एकेडमिक पॉइंट ऑफ व्यू में दोनों को सर्टिफिकेट मिलेगा, एक डिजाइन की सर्टिफिकेट आएगी, एक पेटेंट की सर्टिफिकेट आएगी. ऐसा नहीं बोल सकता. सपोज आपका इन्वेंशन हिट हो रही है इन्वेंटिव स्टेप में, मतलब वही ऑब्वियसनेस में फंस रहा है, तो आप पेटेंट फाइल ही क्यों करोगे? बट यू आर इन अ पोजीशन टू एस्टैब्लिश so there is a differences between earlier one and my one in view of safe configuration surface pattern. तो आप डिजाइन में ही जाओगे ना इन दैट केस. हाँ, आपके एकेडमिक ऑथोरिटी अगर कंसीडर पेटेंट को करता है, डिजाइन को नहीं करता, व्हिच इज नॉट करेक्ट ऑल्सो. आजकल कर रहे हैं, वो आपके ऊपर है. इक्वल इंपॉर्टेंस आपका, आप कौन सी व्यू में बोल रहे हो? मतलब प्रोटेक्शन वाइज?
No, sir. Actually, what I mean to say, that is, if you consider the time span, that is, most of the PhD scholars also, or even though the faculties, they have the appraisals, so they are looking for the pet or to avoid the time as well as the fees, they go design
they go
patent.
for the design. They go for, again you are saying design patent. Design patent is not a correct word. Design is different. So yes, that is your consideration. If you do not have such kind of monetary problem, you have time spent, definitely patent के लिए तो थोड़ा टाइम लगेगा, because it takes big thing, it gives you big. Design takes you small, takes a small thing from your end, accordingly it will give a small thing to you also. So it depends. So आप चाहते क्या हो? आपको मनी में अगर प्रॉब्लम है, दिस काइंड ऑफ थिंग, प्रॉब्लमेटिक टाइम आपको नहीं देना है, आपको 6 months के अंदर ही सब कुछ चाहिए, पर पेटेंट भी 6 months 1 day में हो सकता है. आपको एग्जांपल दिखाया हमने. But yes, don't consider this as the ideal part also. But generally, if your case is expedited, then it would have been granted within 2 years. आजकल तो हो रहा है 1.5 साल 2 साल के अंदर expedited case तो. But definitely, the ultimate decision is yours. Design is relatively easy. ये बात तो है. हाँ, anything else, sir?
Yes, anything from
Anything else?
participants? I think no. So with this, I would like to conclude the sessions, and once more, very big thankful to Mr. A.A. Roy, who has joined the MIT campus on online mode and has given a wonderful talk on the IPR. So thank you very much, sir.
Thank you.
And thank you, audience, also for being patient last 2 hours. Okay, thank you.
Good day.
Okay, sir. Thank you.